Hello and welcome to Research Academy's YouTube channel. Today we will talk about 5 important recent cases for constitutional law that you cannot miss for CLAT 2024 examination. So let's start the video, but before we do, we have 3 important announcements. We have launched a CLAT PG prep kit which has a casebook and a mock book. You can check this out from the link in the description. Additionally, we have online mock tests for CLAT and ALET PG, and we will be starting free CLAT PG YouTube live classes for covering all major subjects for CLAT. This will start from 1st November 2023. So let's come to the first important judgment for constitutional law, which is the case of Anup Baranwal versus Union of India. Now, this is a very important 5-judge bench decision. In this case, the Supreme Court was basically discussing about the appointment of election commissioners and how there is a lack of a law on this matter, and that is why there has not been a uniform procedure of election to this post. So the Supreme Court said that they will issue the guidelines until Parliament makes a law. So in this case, the court directed that election commissioners will be appointed on the advice of a committee which will comprise of the Prime Minister, the Leader of Opposition, and the Chief Justice of India. Now, this case standalone was very important, but after that also has been some developments. The Parliament has come up with the Act already. They have added an amendment. So you can read the CEC and other EC's Appointment, Conditions of Service and Term of Office Act 2023 to understand how the Parliament has now provided for a new procedure for appointment of the election commissioners. Now, coming to the second very important case for CLAT, we have the judgment of Kel Kishore versus State of UP. This is another 5-judge bench decision which is very important in light of MPs and MLAs' right to speech. So in this case, the court was discussing about the parliamentary privileges that ministers of parliament and state legislatures enjoy. And the court was also balancing this with Article 19. So the court was of the opinion that additional restrictions cannot be placed on ministers' right to speech which are not found in Article 19 Clause 2. Because Article 19 Clause 2 already lists down exhaustive restrictions which can be imposed on freedom of speech and expression under Article 19(1). So the court was of the opinion that no additional restrictions can be brought into Article 19 Clause 2. In this case, the dissent of Justice Nagaratna is very important with respect to what will be constitutional tort and whether the party will be responsible for minister's statement or not. So do check this case out because this can be very relevant for your exam. Coming to the third case, we have the judgment of Subhash Desai versus Principal Secretary Governor of Maharashtra. In this 5-judge bench decision, the Supreme Court was dealing with the Shiv Sena rift that happened between Uddhav Thackeray and the ruling government. So in this case, the court has discussed the anti-defection law, and most importantly, the court has discussed the power of speaker in matters of deciding whether a member has defected or not, and also in matters deciding while the election of the speaker in itself is under question. So this is a very important judgment so far as parliamentary functioning is concerned, anti-defection law is concerned, and especially the power of speaker is concerned. This case is also relevant because in this judgment, the Supreme Court has referred the Nabam Rabia case to a larger bench for conflicting with the Kyoto Holohan case. So as you can see, it's a very relevant judgment and very high possibility that this can be asked in your exam. Now coming to the fourth judgment, we have the case of Vivek Narayan Sharma versus Union of India. In this 5-judge bench decision, the Supreme Court was discussing and deciding on the validity of the demonetization exercise that took place in 2017, in which the 500 rupee note and the 1000 rupee note were taken away from the legal currency. So in this case, the court held that under the RBI Act, the central government and the RBI did have the power to carry out the demonetization, and that is why it was very much constitutional. Now the judgment in itself is very important, but the dissent of Justice Nagaratna is also very important because she discusses that demonetization in itself is not an issue, but the manner in it which is done is not correct, as it could not be done under the RBI Act, because if such level of demonetization had to be done, it had to be done via a parliamentary act, as was done in the previous instances as well. So this case is also very relevant and can be asked in your exam. Coming to the last judgment, we have the case of Supriyo alias Supriya Chakrabarti versus Union of India. This is a very recent judgment. Now in this case, it's a 5-judge bench decision. This is the marriage equality case where the court gave the verdict by a 3:2 majority. The court did not grant any relief. They did not hold the Special Marriage Act as unconstitutional, and they also refused to read into the Special Marriage Act to include homosexual couples as well. The majority of the judges also did not grant any relief to homosexual couples with respect to adoption as well. However, the minority judgment of Justice Kaul and Chief Justice of India Chandrachud is very important, because these judges have granted some rights to homosexual couples, but since this is the minority part of the judgment, this is not operative. So this brings us to the 5 very important cases for constitutional law for your CLAT PG 2024 exam. If you like this video, please like and share and subscribe to our YouTube channel.